Good morning, everybody, and welcome. Sundwall, welcome. We're going to go on the record and call State of Utah versus Meggan Sundwall, case 251-401-132. Counsel, please note your appearances.
Lauren Hunt, Julia Thomas, and Sandy Ness for the state.
Scott Williams for Ms. Sundwall. I apologize for my cold. I think I sound worse than I feel. Forgive me if I have to use the Kleenex. I am here, of course, representing Meggan Sundwall, who's at council table. In front of the bar with me is investigator and mitigation specialist, Marissa Sandel.
Thank you. This matter is set for oral arguments on 4 different motions by my count. Defendant's motion to exclude evidence per Rule 502, state's motion to exclude evidence of alleged theft, state's motion to admit other acts of evidence, and state's motion to eliminate to exclude evidence of alleged drug dealing. We're all on the same page?
Yes, Your Honor.
Yes, Judge.
All right. I've had a chance to review them. I think I'm pretty familiar with the issues. If you guys will hit the high points, that will be helpful. I may interrupt you. You both know how I work. From time to time with a question. I may not. It just depends. Anything we need to talk about before we get started with oral argument?
I don't think so, Your Honor. And again, I ask and welcome Your Honor to lead the discussions, at least when I'm arguing and presenting on these motions. These I see as really classic, maybe with the marital privilege, not so much as much, but classic trial management 403 motions and limine type issues. So I'll do my best to be responsive to your questions and relate to a record. You know, we had an expansive preliminary hearing as well. So
thank you. Let's start with the state's motions. What I want to do is work through each of them.
Okay.
Then we're going to take a short break. And it's my hope that I might be able to rule on all of them today.
Okay.
Before we go, we've got some time. Let's try and use it. I know it will help the parties get ready because trial is coming up in just over a month. So, let's start with the state's motion to exclude evidence of alleged theft.
Judge, do you mind if I stay right here?
Wherever you're comfortable.
And obviously feel free to interrupt if you have specific questions, but I think the briefing on both sides does a pretty good job of framing the issue. I think it's a classic 404, 405, 403 issue, as Mr. Williams kind of alluded to. Here, I believe the defense wants to introduce specific bad acts of the victim, alleged bad acts, to argue that essentially she was manipulative, a deceitful person, and therefore, you know, might have had a potential motive for her suicide. First of all, we don't even know. I mean, the alleged theft may have been investigated. We don't know where it went. Where that investigation went. We don't know the conclusions of that. This issue is likely, very highly likely, to become a trial within a trial, which is what Rule 403 in part hopes to avoid. Even assuming, for the sake of argument, that the theft occurred, it's still inadmissible for the purpose that the defense, I believe, seeks to offer it. This is essentially propensity dressed up as quote unquote context, which, as Your Honor knows, Rule 404B, 404 prohibits other acts of evidence when the purpose is to show character and action in conformity with that character. The defense's briefing, I think, makes clear that this is exactly what they want. They repeatedly describe the victim as manipulative, deceitful, attention-seeking, things of those nature, and they want to use this alleged theft as proof of those traits. I think that's textbook propensity reasoning that Rule 404 prohibits. It's not intrinsic. I believe the defense used that word repeatedly. Intrinsic evidence is evidence that directly proves the charged conduct or is part of the same transaction. The alleged theft from her grandparents is not part of the homicide. It's not part of the cause of death. It's not part of any act or omission at the scene. It's not part of the charged offense. It is by nature extrinsic. The only reason that it would even be relevant to this case is, you know, perhaps the theory that it may have provided her a motive for suicide. But even that is speculation piled on speculation, which I don't think we can allow the jury to hear. To be probative of a suicide motive, the defense would need evidence that the victim knew that the theft was discovered or believed consequences were imminent. And there's none of that evidence here. It's not even clear that she knew that she was even being investigated, much less that there was any danger at the time of her family finding out about the alleged theft. I think that it's a pretty long chain of inferences that we would have to jump through to get to this was a prescient enough issue in her mind at the time that it would have motivated her suicide on that day. She did not, there's no evidence that she knew that an investigation was happening, that she knew that anyone was even wise to the fact that she may have been taking money. There's no evidence that she knew that her uncle Mark had caught on. There's no evidence of any confrontation or impending exposure communicated to her. No evidence of fear of discovery in her texts and communications. Obviously, we presented a huge amount of those at preliminary hearing. There's no discussion that she thought she might be found out about that. And simply, there's no evidence that she referenced it as a stressor in her life. So without that evidence, the defense is essentially asking the jury to infer that theft may have occurred. Again, may have, it's alleged. Therefore, discovery was likely. Therefore, the victim perceived that discovery was likely. Therefore, the victim feared exposure. Therefore, that fear motivated her suicide. There's simply no evidence of that. That's a narrative that I don't think that the jury should, that the rules allow the jury to hear. Turning to Rule 405B, I believe the defense cited that character is central to the case, but that's not the test. Rule 405B is narrow, as your honor knows. Specific instances are admissible only when character is an essential element of a charge, claim, or defense. In homicide, the victim's character for honesty, while it is relevant here, and honestly, it's obviously going to be discussed, but on this alleged theft issue, it's certainly not an element of what we're talking about, and it's not an element of any recognized defense. The defense referenced expert testimony, perhaps opening the door to this issue. An expert can't become a conduit for inadmissible character evidence. Rule 703 does not convert inadmissible specific acts into substantive proof for the jury. If the defense wants to offer expert testimony about suicidality, that can be done without turning this into a trial within a trial about whether the victim was a thief or taking money, again, allegedly taking money from her family. And finally, I think this comes back to Rule 403. It would become a mini trial within the larger issue, and the victim would become the defendant. And I think practical courtroom management and fairness under Rule 403, this strongly favors exclusion. Unless the court has any other questions about that, I think those are my main points on that issue.
I don't. Thank you. Mr. Williams.
Thank you, Your Honor. I think that this is a very apt of these motions to begin with, because it implicates a large theme, at least and especially of the defense in this case, and that will, unless Your Honor ultimately we litigate in Your Honor in some way excludes or limits our presentation of it, it will involve expert testimony about two particular utterly key aspects of the defense presentation. One we've talked about is this interesting one of suicidality and the state's continuing insistence that the evidence won't support that. And therefore, of course, our ability to offer counterpoint, counter evidence, and counter argument to the suicidality question. I don't understand at this point that the state is necessarily disagreeing that that issue will be something that would be open to litigation or open to presentation in the form of an evidentiary feature of the trial. Just that this particular, and now we're talking about the theft question, this particular aspect isn't necessary and shouldn't be allowed in the consideration of the totality of the question of suicidality. But second, and as central to our defense is our presentation of the overall consideration of the personalities and character traits of these two individuals, Kacee Terry and Meggan Sundwall, over the course of what the evidence is, a long period of time. And I think 4 years is fair to say in relation to the issues in this case about suicidality, whether Ms. Sundwall and to what extent is engaged in and complicit with the issue of and question of suicidality, but also the state is going to absolutely feature communications by Ms. Sundwall in the course of this relationship that it will argue support the notion that she committed an act in that room. That's the narrow question of the case, of course. And so we have been working with and will be utilizing an expert witness who needs to investigate, know, and utilize in his presentation of his conclusions every feature of Kacee Terry's characteristic, personality traits, characteristics, as well as understanding what he can about Meggan Sundwall's personality and the dynamic between the two that helps inform the nature of of their communications and helps understand how Meggan Sundwall would have gotten to the position that the state will certainly argue is just is contrary to the way people would normally react to someone communicating like Kacee Terry did, and be supportive of a suicide ideation, be supportive and even encouraging that she utilize that method to end her suffering, and to understand how Meggan Sundwall can communicate the way she did and in confidence with a person who, and what Kacee Terry did to help encourage Meggan Sundwall's role, encourage her confidentiality on it, and her alliance it is necessary to understand the features of Kacee Terry's personality that explain that, and those include issues already that we are working with the expert who we gave notice of. It's Kyle Hancock, going to work with the government to get the necessary consultations in order. I don't know if this court knows, we just finished a 2-week murder trial a week ago. And I appreciate that the state knows that, and our communications has understood that the timing of us working up this trial is impacted. We are working with their experts that we just got notice of. And so Kyle Hancock needs to be able to do a full presentation that supports his opinions, needs to consider everything that Kacee Terry did, and that relates to some of the personality traits, the manipulative, attention-seeking traits that she would then really utilize to gain Meggan's confidence, to gain Meggan's sympathy, to gain Meggan's alliance. And again, I mean, the state's position can be that the suicidality was false, but it is not. The evidence in this case is overwhelming that she communicated suicidality. The state's position is, I guess, think that was false. And I don't want to attribute anything to the state to speak up, of course, if they think I'm mischaracterizing their position. But it seems to me that the position is that hundreds and hundreds and hundreds of pages, let alone texts, over 4 years have Kacee Terry expressing her suicidality to Meggan Sundwall, right up to the very day of her death. Well, of her death. I'm treating the 12th of August as her death. Technically, it wasn't her actual date of death. So let's say when she was found unconscious. So the features that, and factors, I should say, that Kyle Hancock, our expert, will need to explain are the management of impulsivity, evaluation and management of risk by Kacee Terry, indicators of deception, fraud, manipulation, and coercion, and management of interpersonal relationships. And of course, that's a key one here because this is about the interpersonal relationship, Meggan Sundwall and Kacee Terry, and whether and how that informs what would be inflammatory communications. You know, why haven't you done it? What do you need as help to ease your suffering? Inflammatory texts that were presented and on their face are concerning to without full context and having to do with I would even help you. What can what communications by Meggan Sundwall that would be counterintuitive without understanding the long history of communications and the personality traits of Kacee versus the personality traits of Meggan Sundwall, and how they elicited from Meggan her communications, her relationship, and her role in that relationship as it pertains to suicidality. And lastly, patterns of relationship characteristics. So in this issue and the drug-related issue, I'll just incorporate this argument right now, Judge, into that consideration. That's what we're talking about is intrinsic. So turning now to this issue of the theft. First of all, respectfully, I just do not understand the continuing reference to any perceived equivocation that it occurred. I mean, I copied into the pleading the conclusions of the law enforcement officer in this case that the crime occurred, and in relation to the conclusions of the agency involved that the theft and elderly abuse is the characterization of that investigation occurred. There was no, of course, there was no defendant to prosecute or further investigate because Kacee Terry was deceased. But I just continue to wonder, if not marvel at any question, this would be any kind of trial inside a trial. She stole. They know how she did it. It was investigated by a bank. It was investigated by Mark, her uncle. It was concluded by our case agent in State versus Sundwall that it occurred. And it was concluded by an investigating agency that it occurred. And I don't know how much further I would need to go on that. So I respectfully don't think we have a trial inside a trial at all. It's just, it happened. The nature of how it happened is known. The nature of the deception is known. By the way, this is also corroborated in the present investigation, the theft and the nature of the theft, by interviews with people who helped facilitate it, including a friend of hers named Michelle. So unless you have more has questions on that subject, I don't think we're talking about any kind of issues of fact that will need to be litigated. And we are truly on how they and if they dovetail in this case in such a way that is intrinsic to what I've just explained as a key feature, two key features of our defense. She was, at least arguably, suicidal. And this kind of behavior is behavior that is important and quintessential to our experts' presentation of his opinions about who Kacee was, how she presented it, and how she got into this relationship, and how Ms. Sundwall responded to it. On the argument of suicidality, respectfully, it's almost more probative that somebody may not have known when the axe was going to fall than they did know. I mean, the idea that we would have to present some idea that Kacee Terry knew the gig was up with this theft doesn't make sense to me. It's part and parcel of a person who was engaging in reckless activity, building a house of cards that would, at least we ought to be able to argue, imminently collapse, and that she had the out of suicide in response to it. There's no reason, we ought to be able to argue that this theft activity is something that one would reasonably believe is going to be that is going to become known, and it is something that is a boom that is going to fall. We shouldn't have to prove that she knew it at the time. That wouldn't be fair. And quite frankly, if she hadn't been deceased and the investigation had continued, we may have known. She may have interviewed or something. So I respectfully don't think that evidence that she knew in any way equivocally or unequivocally that the theft activity had been discovered, we ought to be argued that anybody would know it's going to. And when you combine that also with what we're going to talk about with her incredible drug transactional history, our argument is this is a person who is recklessly building a house of cards that is going to fall. And when it does, she has a suicidal out if she hasn't committed suicide already. So I hope that helped inform our position on the subject, and ask your honor if you have any other questions. On the question of trial and a trial or whether this happened, again, I have tried to point out that I just don't think that's a legitimate question, but we have more. There's more in the discovery that helps rebut any notion that it's equivocal whether the theft occurred. And we're not going to try to suggest there was more than just this, for instance, although there's plenty of evidence that actually was. Kacee Terry engaged her Venmo account in ways that could otherwise look suspicious with theft activity. We're only talking about what was investigated and concluded on the credit card matter with the grandparents.
Thank you. Should reply.
Yeah, just briefly, Judge. I'll just say it's interesting that Mr. Williams finds that a conclusion in a police report from a detective is enough to say unequivocally that something happened. Obviously, there was no trial, there was no conviction. So yes, it is still alleged at this time, although it was, minimally investigated before or after her death.
Adult Protective Services did support it.
Yes, it was supported, but again, this goes whether the theft happened or not. It still does not overcome the evidentiary bar here. Mr. Williams saying that his expert needs to understand the Ms. Terry's personality and the dynamic between she and Ms. Sundwall is probably true, but there's ample admissible evidence that allows him to do that. There's no evidence, frankly, that Ms. Sundwall knew that Ms. Terry was stealing from family members. That's not in any of their text messages. It doesn't go to Ms. Sundwall's state of mind at all. There are plenty of text messages where Ms. Terry is communicating to Ms. Sundwall that she is suicidal. Whether or not she actually was is obviously going to be a main issue for the jury to decide. But their expert certainly doesn't need this kind of inflammatory character assassination of just she's a thief. Certainly we're going to have to concede, and we do concede, that Ms. Terry was lying about a number of things. A number of people in her life, including her family, believed that she had cancer. For instance, she ample text messages to Ms. Sundwall are Mr. Williams references this house of cards. She's talking about being in hospice. She's giving what we presented at preliminary hearing as pretty ridiculous lies, getting to the level that they're pretty ridiculous that anybody would even believe them, much less Ms. Sundwall, a trained nurse. So yeah, they're still able to make those arguments that she is building, these lies and lying to people. But bringing in this theft that, although was maybe substantiated as part of an investigation, there's no conviction of it. And it carries the risk under 403 and 404 of the jury just hearing and believing that Kacee's a bad person. She's a thief. And while they certainly are going to hear unsavory facts about, obviously Ms. Terry's was a complicated person, but bringing in this that there's no evidence that Ms. Terry knew that the gig was up or that she was being investigated about the theft. There's certainly no evidence that Ms. Sundwall knew about any of that, so it doesn't go into their personal dynamic. And it only becomes relevant as a motive for suicide if Ms. Terry knew that as Mr. Williams said, that it was imminent. He said we should be able to argue that this house of cards was going to imminently fall. This theft issue, there's simply no evidence that that was part of this, that she knew that she was going to be investigated, that she knew there would be consequences for it. If it did happen, it was going on for a number of years. Why now? Why would this now be a motive for her to commit suicide when there's simply no evidence that anyone knew that this was happening? I think it's irrelevant to the overarching issue. Whether their expert wants to take it into consideration as part of his ultimate opinion is fine, but the jury should not be able to hear about that act specifically. I think it goes against all the rules I've cited, 405, 404, and 403. It then becomes a trial about whether she did commit theft, what are the, how was it investigated, what were the findings, what were the conclusions. And again, that trial never had an opportunity to happen. Charges were not brought. And most importantly, there's just simply no evidence that Ms. Terry knew that this was even an issue that was coming to fruition or was going to be a problem. So it certainly didn't inform, or there's no evidence to suggest that it informed her motive for suicide on this day.
Thank you. All right, let's move on. Excuse me. Let's move on to state's motion to admit other acts. It's docket number 133.
And to clarify, this is about the defendant's time card fraud issue.
Yes.
Okay.
Yes.
Again, Judge, feel free to jump in if you have specific questions. The state is certainly not intending to use this evidence to smear defendant. We're explaining motive. We are not offering the time card fraud to show propensity or bad character. We're offering it for a very narrow, classic 404B purpose, which is financial motive, which is obviously highly important in this case. The defense in their response, they concede that job loss is relevant. They make that concession. So the only dispute is whether the jury can hear why that job loss happened. But what the defense is asking this court to do is force a misleading narrative to the jury. If the jury is told only that the defendant lost her job, they would naturally infer benign explanations, a layoff, a clinic closure, a voluntary resignation, health issues, things like that. That would be inaccurate, and it would materially dilute the probative value of the evidence. Rule 404B does not require the state to present motive evidence in a misleadingly sanitized form. The reason for termination here matters because it affects the suddenness, the severity, the recoverability, and the future prospects of Ms. Sundwall's finances. The reason matters, Judge, because it explains why her financial situation escalated instead of stabilizing. Losing a job for cause is not the same as being laid off. It affects employability, income recovery, and financial pressure, especially when the reason she lost her job is for time card fraud. The defense's position would turn Rule 404B into a requirement that motive evidence be stripped of meaning. And again, I already said the defense wants to present that she was not fired for theft, just that she lost a job. She was not terminated for fraud, just that she had a career change, something like that. She didn't lose her license. It's just an employment disruption. Again, those are misleading, and they go to the very heart of what motivated, in the state's theory, and what we believe the evidence will support, what motivated this murder here. I think any dispute.
Sorry to interrupt. Are we in danger of turning this into a mini trial regarding time fraud?
No, because again,
will that affect the jury on how they use the term fraud as it relates to Ms. Sundwall?
We're open to if terminology is at issue. We're open to using whatever terms Your Honor is comfortable with. But again, talking about findings in an investigation, we don't actually need to litigate whether, and I know that Ms. Sundwall disputes that she committed time fraud, but that was the finding of IHC. That was the reason for her firing. And that's all part of discovery. So they made that conclusion, and that is the reason they fired her. I know it kind of sounds similar to a trial within a trial about what we just talked about with Ms. Terry allegedly stealing from her family. But this is far more prescient and far more important because it goes to the defendant's mental state at the time. Her financial pressure was escalating. Her employability was affected. She did find other employment, but being fired for time card fraud, or however Your Honor is comfortable putting it at trial, that does put pressure on her. And that financial pressure is precisely the state's theory of what motivated this murder. Just letting the jury assume that it was for benign reasons, that she just lost her job, that misses the picture of her desperation. And her financial desperation goes to the heart of the state's case. It goes to the heart of the motive behind this. It goes to the heart of the aggravating factor that we need to prove. We wouldn't need to litigate whether it actually happened. What is most important here is that IHC determined that it happened and let her go because of that. And so Ms. Sundwall was out of a job at that time because of IHC's determination, and that directly reflects on her desperation. Does Your Honor have any more questions about that?
I don't, not right now. Thank you, Mr. Williams.
I find the issue a question of fact in this particular motion rather extraordinary when compared to the last motion. IHC did no investigation. They didn't even let her really comment. They just terminated her. We could get into the trial why they did it. They closed the clinic 2 days later. By the way, Ms. Sundwall, it's material if they want to show hardship. Probably that she didn't have in February of 2024 that she lost this source of income. I understand that to their motive theory. How or why or anything else, I cannot understand except for if it is to somehow smear her. And by the way, I mean, I guess we have to show some cards in response to this. She just went to her other job full time. And so, they can argue that this loss of income here was somehow 5 or 6 months prior to the death of Ms. Kacee, relevant to their motive theory. I get if they want that. How important that is or valuable, I'm sure I don't know in the end, but they have the right to their evidence. That somehow she did it by means of fraud or untruthfulness is just never determined. Unlike a professional agency and the case agent in this case on the theft issue, no investigation was done. It was never referred out. According to IHC's own documents, it was never referred out for any criminal investigation, any theft-related investigation. By the way, I think if I recall, and I can be corrected by the state or my team, but I think we are talking about 82 minutes of overcompensation. 82 minutes. So this is a trial, in a trial, the outcome of which goes to nothing material about her character or whether she's a fraudster or thief. The only thing that's material, if they want to introduce it, is indeed she lost her employment on this employment with IHC. Sorry for the record, I should be clear. The IHC employment she lost on February 1st, 2024. I can't imagine how anything beyond that is material or probative to the case. Are there further questions to elaborate or elucidate? Like I said,
I don't have
well,
any.
it's probably not even relevant what I said about her having the other job, but That's what I have for Your Honor, and open to questions.
Thank you. Distinguished reply.
Yeah, just briefly. To me, it's very clear that the difference, the fundamental difference between these two issues, the victim's alleged theft and Ms. Sundwall's firing from IHC, is what it has to say about their mental states at the time, their motive to do something. In Ms. Casey's, in Ms. Terry's case, did she have motive for this reason to commit suicide? And there's simply no evidence for that, because there's no evidence to suggest that she knew the hammer was dropping on her for the alleged theft. On the other hand, this time card issue, obviously Ms. Sundwall knew that she was fired for this reason. Obviously it affected her employment prospects moving forward, her current job, her income, her financial desperation. Whether it was 5 months before, the text messages will show, and Your Honor got a piece of this at the preliminary hearing, that's when things started ramping up. That's when the defendant got more desperate. That's when she started suggesting suicide more frequently to Ms. Terry. And it's because she was in financial dire straits here. And again, it's going to mislead the jury to just think, yeah, she just lost her job. It dilutes the motive here. It dilutes the fundamental motive that we have here, which is financial stress, and what the defendant escalates to when she is in financial stress. And this is a primary piece of that. Obviously, we put this in our briefing. We are open to a limiting instruction. We can work on phrasing that with Your Honor and with defense. The only purpose that the jury would be able to use this information is for motive only. We would put in a limiting instruction that this is not to show that she has a bad character. That's not why the state's introducing it. It would be for motive only, and it's highly informative and probative of this motive, which is not normally a thing that we need to prove, but obviously is the aggravating factor here.
Right, I know that you might not prefer a tit for tat, and I don't mean to, but I did leave something of a factual information you might find important or relevant.
Go ahead.
And because it was referenced on license, it is not true or correct that this had anything to do or any impact on Ms. Sundwall's license. She, like I said, the actual evidence is, and this might be information for Your Honor on this issue, or at trial if we don't prevail on this particular motion, but it didn't change her hours of work, which she just supplemented with her part-time job that she also had. But she had no license ramifications. This was not referred to Doppel, and her license isn't even the only issue with her medical license and nursing license right now is it's suspended. It's not terminated. And that was based on these charges. So nothing like that happened. Do we have to litigate all that and point all that out to a trial just because the state wants this financial factor of her losing this job in evidence, plus why she supposedly did? If we just take out the why, there are none of those issues.
And sorry, Judge, I do want to correct the record. I did not mean to imply, I forget what I said, but yes, the state knows that she did not lose her license over the IHC issue. It is suspended because of these charges. We don't intend to bring that up in this way. That's not part of this motion. So unless the court has further questions on that.
Thank you. Let's move on to state's motion in limine to exclude evidence of alleged drug dealing by the victim.
A lot of my points might be similar to the alleged theft here, so I won't belabor them, but I want to be clear, and I hope I made this clear in my reply. The state's not asking to exclude toxicology evidence, prescription status, or the victim's own suicidal communications about obtaining pills. We know that there's a number of communications to Ms. Sundwall where she's talking about methods and means of committing suicide. We're aware that those things are going to come in with proper foundation. What we're asking for with this motion is a narrow order prohibiting the defense from labeling the victim a drug dealer, accusing her of trafficking or distributing controlled substances, or arguing speculative drug network narratives that are irrelevant and highly prejudicial. Mr. Williams made reference in the preliminary hearing, I believe a few times, to some notion that the victim was dealing insulin. There is no evidence that there's not even a speculation that that was happening, as far as I know, in reviewing the discovery and the investigation. There is evidence that she was selling Xanax, and obviously Xanax was present in her system. It's part of the autopsy report. The fact that she was taking Xanax without a prescription, I believe, ought to come in. I think it will come in. I don't think the state is shying away from that fact. We're certainly not trying to mislead the jury about the drugs in her system at her autopsy or when she was taken to the hospital. But what we don't want is, again, a character assassination of the victim. She's a drug dealer. She's a bad person. She's dealing insulin, of which there's no evidence to support. And so that's the narrow question here. I believe it comes down to 403. And obviously, a lot of these facts are going to come in. I believe that we'll even hear from somebody that was dealing her Xanax. The fact that she was taking Xanax without a prescription is something that the jury will probably end up hearing with proper foundation. But labeling her a drug dealer or speculative throwaway comments that have no support in the evidence about dealing insulin or things like that, that's what we're asking this court to exclude.
That's kind of the issue I have right now is based upon the arguments, the proffers and the prior hearings, I don't know if I know what the evidence is to even rule on its admissibility.
That's an interesting, yeah, that's an interesting point, Your Honor, and it may bear, if you desire, on a fuller exploration of and presentation of what is in fact just astonishing activity over a long period of time that involves Ms. Terry clearly doctor shopping opiates, using her massive prescription for opiates from the doctor she did have, especially Masteller. You do know a little bit about that from preliminary hearing. Utilizing other sources, selling her opiates to obtain medication that Masteller would not give her. That's the benzodiazepines. And involved in a web with multiple people in the distribution and sale of narcotics that is going on while she communicates the use of those things to commit suicide, communicates that with Ms. Sundwall. With these other folks, it's just a web of, and it was the state that called it drug dealing. I don't care what we label it. It is the activity in and of itself. It goes to so many things. The confidence she creates, and this is according to our expert opinion that is in the course of being investigated, but I expect to be a huge feature, is she utilizes that activity in telling you. I mean, this is felonious activity. It's extraordinary. And that she tells Meggan Sundwall of it. That's a personality trait on behalf of Ms. Terry that is a borderline trait that is common to get the confidences of people that you can maintain a surreptitious relationship with. Surreptitious in terms of whether or not, you are suicidal, or the level of deceit that she can gain and manipulate Ms. Sundwall with. It includes this sort of activity. I just cut out the one example in the memorandum that we filed because, I mean, it was directly on point as to how she is telling Meggan Sundwall, I am dealing in drugs and I'm hoping they're laced with fentanyl so I can die this time. And, I don't know. And, I maybe shouldn't be saying this to you, right? That's the feature of this is a crime. Maybe I shouldn't tell you things like this. that those are manipulative behaviors to induce a continuing relationship of confidence and with another person, in this case, Ms. Sundwall. But it's important, I think, for the court to know, if you don't feel like you do already, the extraordinary extent of this activity. When you read through, for instance, Detective Farney's report, which has hundreds of pages in her report about relating communications she's pulling from the relevant downloads, primarily Ms. Terry and Ms. Sundwall's communications. They'll be interspersed with dozens of drug transaction related communications as well, going on while she's in the process of this relationship with Ms. Sundwall, some of which she, like I say, divulges to Ms. Sundwall in what we submit is a very manipulative way, and incorporates into the question of whether she'll use them for suicide. That's why we thought that was so poignant for the one communication. I mean, it's on just, it hits up, that one text hits every point here, right? It hits, maybe I shouldn't say it, it hits, I'm involved in drug activity that would allow me access to means of suicide. I hope they work this time. I think I'm paraphrasing. I don't have it in front of me. I'm sorry, but it's cut and pasted into the memo so that, so I can't mischaracterize it. But it is true that it has not yet been developed how incredibly extensive this activity was, how it affected other witnesses. They interviewed some of the other participants in this drug-related transactional involvement and engagement. That also, by the way, it appears included financial frauds and use of bank card and Venmo transaction and other sites that, quite frankly, would be federal crimes. We're not interested in the criminology or that she committed the crimes as character evidence. It's that she did this activity and how that reflects upon her character traits that explain the comorbid, if you will, relationship between she and Ms. Sundwall that would explain counterintuitive communication and behavior by Ms. Sundwall. It's a counterintuitive behavior analysis of the evidence the state wants to present. They want to use Ms. Sundwall's communications as evidence of guilt. And we need to explain the counterintuitive way that those communications occurred, and it requires the dynamic between what our expert is flat out going to have no problem describing borderline personality disorder traits and the effects that those sorts of traits on borderline, for Kacee Terry, and the effects and ability to utilize those traits on a person like Meggan Sundwall that helps inform what otherwise seems, without that context, counterintuitive remarks by Ms. Sundwall. So we can manage, even in the form of submitting a police report, inform Your Honor further on how extraordinarily pervasive this activity was. The insulin thing it comes from this, Judge, and I told the state this when I brought up the transference of insulin question. It came from a communication with a third party that we learned of while looking at the phone download evidence. It appeared that in communications between this other person, there were some that suggested that that person needed or could not afford insulin and they were a diabetic, and that Kacee Terry said, well, I have access to it. Not that, I will admit that in that thread, it seems to be a friend, by the way, who does not appear, I don't think, by us, appear to us that is part of the narcotics activity that I've described. seems just to be an insulin needer who is communicating hardship, financial maybe, I can't remember, or if it was access hardship, and the representation by Kacee Terry that, well, to paraphrase, I've got access to it, which of course we know from the facts is true. Her uncle clearly described to your honor at preliminary hearing how he wouldn't even be able to account for the massive amounts of different kinds of insulin that are all, in that house, in a fridge downstairs, et cetera. So that's what I'm talking about there. And if I explained to the state that was the source for that. We do not see evidence that she transacted in, in insulin selling or buying. Although, of course, it would be pretty interesting to know if she said she thought she had access to insulin, since one of the questions may be, where did the insulin in this case come from? And certainly a jury should know she thought she could get it easily from her household. That's separate, right? That's not part of what we're calling drug dealing. So I can see that. We do not see evidence that she was involved in, transacting drug dealing in insulin. We're talking mostly about the extraordinary benzodiazepine, an opiate, and another promethazine, and those sorts of drugs that are in her system, as you know from the evidence. But it's everything she was doing as a dealer and a manipulator and a manager of that covert activity that it feeds into our expert conclusion as well.
Thank you. Reply?
Yes, Judge. First of all, the promethazine and the opioids she was lawfully prescribed, and the evidence supports that. The only drug in her system that she was not lawfully prescribed, other than insulin, is Xanax. And if the defense wants to introduce a text to Ms. Sundwall or multiple texts where the victim is saying that she obtained pills, that's certainly different from accusing her of drug trafficking. And I think Mr. Williams' response here has been pretty telling. She's manipulative, she's deceitful, she has this web, she has this network, and this is precisely what Rule 404 seeks to prevent. This is precisely what the state is seeking to exclude. Are there facts that are going to come out that she was using Xanax, that she represented to Ms. Sundwall that on a number of occasions she could get pills to kill herself, including insulin? Of course. Did she use those? No. The time that she died is the time that Ms. Sundwall came over with, I'll remind the court, the text right before saying, take promethazine while it's happening, so you're out while it's happening. That's a paraphrase, but I think it's clear that the defense intends to use this as they need it for their expert to show that the victim is a deceitful, manipulative person. And that's character evidence. It's not allowable. It's not admissible under the rules. If we have to sanitize some of the facts, I think we may be talking about terminology here, but what I don't want the defense to be able to do, and what the rules don't allow, is making it sound like she's this awful person that is this drug kingpin that is involved in networks and dealers, and is constantly dealing drugs. What she told the defendant, whether or not those things are true, and I think the evidence supports that much of what she told the defendant is not true, that's a separate question. But I don't think, relying on this extrinsic evidence, specific instance evidence to say that label her as a drug dealer and a trafficker and involved in all these networks is precisely what 404 is trying to accomplish.
Thank you. Let's move on to the last motion, defendant's motion to exclude evidence pursuant to Rule 502.
Could I have just a moment?
Of course.
Your Honor, this particular motion and I noted this sort of at the outset of today's hearing, really does implicate a pretty legalistic framework with that. This happens to be the only pleading process that involved citing a single case. The other three motions didn't have a single case cited by either party. This is quintessential law, marital privilege, and it's presumptively exclude controlling legal feature to exclude evidence. The only way the state can prevail is to avail itself of an exception. Now, I submit, and this was my intent, at least, to be the core of the reply memorandum, is that the action that is required to facilitate this exception under Rule 502 is all has to do with really actus reus notions, that the communications at issue have to be done to enable a crime, to plan a crime, to enable a doing of something. I mean, that's what the specific language of the exception and the case law says, the case law cited by the government. The text communications in the government's memorandum are, I think there are 3. And I submit, Your Honor, that there's nothing about these 3 communications, and we can look at them. First of all, the first one is almost 4 full years before the events leading the ultimate death of Kacee Terry. The other one is in relation to, or is on April 29th, so that 4 months before, and then July 16th is a month before. Those communications, first of all, as I submit in my brief, as you saw, these are of the quintessential confidentiality nature of the marital privilege. And I don't hear the state, I don't believe, and you'll hear from me in a moment, but I don't believe, my understanding at least, isn't that they're taking any exact position that these weren't meant to be made in confidence. So we are only about this connectivity to a crime or tort, that they have to be part of the planning, part of the effectuation of a crime. And they just don't have any feature like that. I mean, they might be, I feel like the state wants to say, well, there are indications that she has a motive, or more support for our notion that she wants to enjoy a financial benefit from the passing of Kacee Terry. But we're going to hear all kinds of evidence on that. But that makes them quintessentially part of the marital privilege. They're about money. They're about marital finances. It doesn't say, look, if it said I have a plan, it'll sue me over. If it said, we're in dire straits financially, but I'm going to fix that if you'll drop me off at 10 o'clock at Meggan's house tonight. It doesn't say anything like that, right? It doesn't. Those would be a problem on a marital privilege. They would be connected to criminality in the form of an actus reus and maybe a motive. We have a really interesting case here because, as counsel pointed out, where motive normally isn't an element, of course. And here we have it as essentially as the aggravating factor that is charged. And so it's a quasi, it has a different existence in this case than pure motive. But at any rate, that's my position. I do not see how we read anything into this other than the state position. It says, see, she was really hoping and communicating to her husband that she would enjoy a benefit. And without saying plan specifically in the communication to the modus operandi and stuff, I don't see how it falls outside the privilege. Do we have questions on this
I
subject?
don't. Thank you.
Thank you, Your Honor.
Ms. Hunt?
Thank you, Judge. Mr. Williams is correct. The state concedes that these are confidential spousal communications. The only question for Your Honor is whether the exception under 502E2 applies. But the defense's legal test is wrong. It doesn't require, that exception does not require mechanics. It does not require the communication to include instructions, logistics, or an express plan. It covers communications made in whole or in part to enable, aid, plan, or conceal. The rule is broader than Mr. Williams' framing here. If the exception required the spouse to be enlisted as an accomplice or told the details, the exception would be meaningless in many serious crimes because offenders often do not spell out the mechanics in writing. These are not generic statements about marital finances. Each message explicitly ties the defendant's financial distress to the victim's death and anticipated inheritance. She talks about being stuck forever if Kacee outlives her. Talks about counting on the thing with Kacee being true to bail us out. Talks about unless Kacee passes and she really does leave me the money. That is motive evidence, and it's motive evidence expressed as a continuing expectation, which I think goes toward the exception outlined in 502E2. In the briefing, the defense's marital harmony argument, I believe, is upside down. Their policy argument misapplies the purpose of the privilege. Rule 502 exists to protect marital confidences, not to create a sanctuary for communications that advance criminal conduct. That's precisely why 502 contains this explicit crime furtherance exception. Yes, one of the texts is years ahead of time. We're obviously not offering this as day of planning, but what we're offering is continuing motive thread and the fact that her husband was aware of that. Again, the remoteness of that one text, the other two are far more closer in time to the event, but the remoteness of the one text goes to weight, not to privilege. The exception is not limited to communications made on the eve of the offense. It applies to communications that form part of the planning or enabling of the crime. These messages, again, reflect a continuing financial motive tied to the victim's death, spanning the relationship and culminating shortly before the homicide. And obviously, she's talking about these things to her husband. A point I will make, we're obviously not going to try to compel her husband to testify against her. These messages were obtained through lawful search of her phone. And so the foundation can be laid through the detective. That's not a route we're going where we're going to try to make her husband testify against her. But the exception here, I would argue, does apply. And unless the court has further questions.
I don't. Any reply?
Yes, I mean, I guess this will be a bit repetitive, but it'll maybe be said in a different way that could help my cause. As the state just admitted, the finding will have to be that the information here advances criminal conduct. By the way, I don't recall a single case that has to do with motive. And then the words of our exception, the statute, right? The rule, sorry, 502. They must be about enabling a crime, aiding a crime, planning a crime, concealing a crime. That's what these have to be. And I submit it's objectively, apparently related to. I defy that connection under the facts.
Thank you. I think that's all the motions. Is that correct?
I think it is pending, yes, Your Honor.
All right,
Yes.
I want to thank you for your pleadings. They've been helpful and for your arguments today and for your professionalism. In a case like this, that doesn't always happen. So thank you both. We're going to take a short recess. Don't go anywhere. We'll be back in just a moment. I'm hoping to rule on all motions today.